The broadcast is now starting. All attendees are in listen-only mode.
All right, everyone. So we're going to go ahead and get started. Again, this is Martina James Nally for those of you who have just logged in. We are recording this for posting later. It'll be up in about 24 hours. We have Darren Coffey with us and Susanna Smith from the Berkley group that will be giving our presentation, Code Enforcement Case Studies. Just a reminder, our next webinar will be January 23rd. We're going to skip the December one due to the holidays. But if anybody has any questions in the meantime, you can reach out to myself or any of the other APA Virginia board members. And at this point, I will turn our monthly webinar, Your Hour with APA, presented by the Berkley Group, over to Darren Coffey and Susanna Smith from the Berkley Group.
Thank you, Martina. Appreciate it. We appreciate the opportunity to be here in front of all these folks again. Hopefully we'll be able to share some of our collective wisdom on code enforcement over the years. I do have with me Susanna Smith, who's going to be doing most of this presentation. I will say that the crazy title of this was my silly idea. We don't have enough time in an hour to go from A to Z, but what we are going to do is focus in on vehicles and floodplain, and those are going to be the main case studies that we look at. So there's the V to F portion. We are going to start this off by doing an intro and just basically go over some basics of code enforcement. There is no one way to do this. We have 30 plus attendees on this call, and there's probably at least 24 ways that people do code enforcement. What we're trying to do here is say, here's a technique that we've used over the years that we found to be successful. Code enforcement cases can be very complex, and we're trying to boil it down to get it as simple as possible. So, you know, with the most severe code enforcement cases, I would say 90% of code enforcement cases are resolved after the first or second contact. It's kind of like anything else in zoning. It's that 10% why you have a zoning ordinance. It's that 10% that causes all of the need for what we're about to discuss with regard to code enforcement and how to approach it. So you often have repeat offenders. You have communication challenges, and you only have so many tools at your disposal. However, I think hopefully you'll find after this presentation that maybe you have a few more resources than you were aware of.
Good afternoon, everybody. I'm Susanna Smith, and I hope that the uploaded copy of the web presentation on I guess this page is available to everyone if you want to open that up and take some notes later, or I'm hoping that would be helpful. It's a copy of all the slides. Our contact information, of course, is at the end, and we're always happy to answer questions. Code enforcement failures are really very important to make sure that they don't happen. You want to have a successful code enforcement program, because if you don't, then you're going to have greater issues with other folks not wanting to comply, and of course accountability to your to your mayor, to your local officials, and to other departments that are going to depend on you. So you want to make sure that you have a good, tight program. And we're just going to offer a few ways that we've found work for us in the past.
So what we're going to try to do in this presentation during this lunch hour is talk a little bit about how we handle complaints, maybe a best practice, if you will. Again, we realize that different jurisdictions do it differently, and we've seen that a lot, but this is just for purposes of this discussion, and hopefully it'll help be a good model for some folks to maybe look at. Also, as I mentioned, there are available resources that a lot of folks, I don't think, are aware of. I also meant to say in the introduction that we would love to have questions these webinars haven't been very conducive to questions, but with this issue in particular, it would be great if we could field questions, and if you want to submit them as we go, we can try to roll those in and not just save everything toward the end. Probably 2/3 of this presentation is going to focus on floodplain issues, which I don't know a whole lot about, but Susanna does, and we have a lot of pictures in that section that I think you might find interesting, hopefully. We're also going to be talking about the notice of violation process and, as I mentioned, the case studies. So with complaints, when you're receiving them, there's definitely a right way and a wrong way to handle it. And if you don't want to have to deal with it over and over and over again, then we suggest that you do the following. And that is basically, one of the things I tell folks is be polite, firm, and professional. If you're doing 2 out of those 3 things, you are going to stay on the high road and be able to be the calm, rational one in the conversation. Listen carefully to the complaint when you're talking to the complainant, and try to assess, if it's not obvious, what they would like to see, and try to manage those expectations as to what is realistic and what is not. You're going to want to document the conversation with the complainant, and that is not necessarily subject to FOIA. One of the exemptions under the Freedom of Information Act is code enforcement, and what we have always done is keep that private so that there is no he said, she said. By the time they call the locality, typically it's neighbor ratting out a neighbor, and it can devolve quickly. And so when a violation is documented, that person always wants to know who called it in. They usually know, but they don't find out from us. We try to recommend also that there's a central processing. There's a one-stop shop, one number to call, or if you call the manager's office or the community development office or the public works office, that it is basically routed to one place so that there's an efficiency there in processing the complaint and the uniformity in doing that. The goal is, if and when you have to go to court, your case file has been done the same way for each case, and you win when you go to court. So once you've gotten the complaint, you want to assess whether there's actually a violation, which means you got to go out there and look at it. You got to talk with the person, and you want to at least follow up with them, even if it's informally in writing in some form or fashion. In my experience, and I think Susanna as well, a lot of times you can resolve a code complaint just with this initial visit. You don't have to issue a first letter or a notice of violation, whatever you want to call it. You can just document that you had the complaint, you had the contact, and then it was resolved. And I would say, again, that's, in my experience, that's at least half, if not 3/4 of the cases. You're going to want to, if there is a violation, and you start looking into it, you're going to want to look at the history of that property and see if there are other issues. With the most egregious cases, usually there are other issues. They may have a lien on the property, or they may end up getting one as a result of this process. But, have there been any conditional or special use permits issued, any rezonings, any other code complaints, any other special circumstances going on the property? Is it a grandfathered use? Have they expanded that use? Are there other issues with being a legally non-conforming use that are going on here? What changes maybe have occurred over time? And then other local agencies and departments, what has their contact been, if any? And you want to make sure that the communication at the local level is occurring efficiently and effectively. And then, as we'll get into here very shortly, there's state agency and federal agency assistance that's available as well.
Yes, and in my background with code enforcement, I've had occasion, of course, working at the county level, at the town or city level. I've found that a lot of times If I have a particularly egregious case or someone who's just being a little hard to get a hold of or hard to get them to come into line, a lot of times other agencies will also have had dealings with and we'll run into each other either in the field or just by in the case file. There may be some letters or some interesting things that you start sharing information, and you can work together to resolve these outcomes a lot of times a lot more quickly than you could on your own. And that's not to say you're going to go rat these people out to someone. It's literally just, let's share some resources and try to avoid duplication. Let's by all means not give the poor property owners some conflicting direction. You never want to do that. I can't do this because, FEMA said do that. Well, I can't do this because the Motor Vehicle Board says do something else. You want to make sure that you're telling them basically the same thing, or at least things that dovetail. Of course, this is how you assure that the case goes away and doesn't keep cropping up.
All right, so the process that we recommend, we try to boil this down. Again, this can be fairly complex. It can be overwhelming, but it doesn't have to be that way. It doesn't have to be difficult. You basically receive the complaint, you gather the information, and then you figure out whether there's a violation. That's the first thing you do. And again, with that complaint, I recommend strongly that it be kept anonymous. It doesn't matter who. I always tell people this with zoning: there is no who in what we do. It's what, when, where, how, and it's the same with code enforcement. And so you want to document it, time, location, pictures, establish communication, do your due diligence, basically. And that takes time, and a lot of times there's a mismatch in the locality with how they want code enforcement done with the resources that are available to do that. And gathering that information is where most of the time occurs. And so if you ascertain that there was a violation, again, usually there's this verbal contact, whether it's a warning or a heads up. I think it's best to do it in person if at all possible, but just trying to get up with the responsible party, which very often, ultimately the responsible party is the property owner. But sometimes if it's a rental property, the renter will fix it. If they don't, then who's going to get that written notice is the owner, probably with a copy to where the violation is occurring. So you give the verbal, and again, a lot of times that fixes it. If it doesn't, then you issue that first notice of violation, or the first contact, first letter, whatever the terminology is in your locality. You want to be very specific. You obviously need to quote the state code section that sets forth the appeal process and gives that 30-day clock, and gives the who, what, when, where of how they can appeal. And you're going to want to show the documentation. You describe what the violation is, what code section it pertains to, and then a picture's worth 1,000 words. Here it is. On this date, this photo was taken, and that's why we're writing you this letter. And again, after that 30 days, it's a thing decided. So there technically is no appeal. If it goes to court, the judge should look at them and say, why didn't you fix this? You need to fix this. So whatever isn't caught after the first contact and the verbal part, again, 90% plus in my experience, after that first letter is written, it's resolved. Why we're here today is for the 10%. And that's where you do the second notice and the third notice, or as we're saying here, just after that 30 days, you want to say, you need to resolve this. Here's your revised time frame. It's a week, it's 10 days, it's 5 days, whatever it is. And then we're turning the matter over to the local attorney. So we're going to go through a number of case studies, and by we, I mean Susanna, because she put together this presentation. which I'm very thankful for. And these case studies are her experiences in dealing with two issues that I think are very, very common in localities. Vehicles, whether it's dealership, which is what we're going to be talking about, or inoperative vehicles. I mean, it's something with cars in every locality I've ever worked in, whether as a consultant or as an employee. It's just been mind-boggling what percentage it takes up for code enforcement. And then floodplain issues, which depending on your jurisdiction, you may have a lot of this or you may not, but it's definitely interesting, and I would encourage everyone to stay with us if you can when we get to the floodplain portion. Susanna, the rest of this is yours, I think.
Thank you, Darren. And as he said, I think a lot of localities struggle a little bit with the car question, whether it's inoperable vehicles or whether it's junkyards or whether it's folks trying to sell cars on the side of the road or whatever. But there is a process. If you're dealing with a used car dealership, the Virginia Motor Vehicle Dealer Licensing Board is actually very, very, very happy to work with you, because a lot of times where their enforcement is sort of getting into the gray area, yours picks up. And it actually, number one on their list of things to look for is local zoning compliance. If they don't know that they're out of compliance with their zoning, there's nothing they can do. But if they do know, they will be very, very happy to help you get these folks back in line. So with that being said, we have a case number 1 of a used car dealer. We had multiple complaints with this gentleman. He'd actually relatively recently acquired this particular dealership. However, when I look back in the case file, there was a long history on the site itself that sort of went back before he got it. But the neighbors had complained that he was parking in the right-of-way and on their properties, attorney, a veterinarian, I think, next door. And while local police can and will enforce parking in the right-of-way, and the neighbors may tow the vehicles, if it's an ongoing thing, maybe zoning is certainly appropriate to check into and see what could be done. There are some minimum requirements, of course, that you're going to want to have a place for your customers to park, and you're certainly not going to want to have unpermitted activities going on a site. And this particular gentleman looked like he had some of all of that. And so I used my little 3-step process. I looked in the case file. I found the past violations, but they were the previous owner. And I talked to the field inspector with the Motor Vehicle Dealer Licensing Board. And he said actually he was a new owner. He had no issues with him. He had a clean site visit, and so how could he be helpful? Because we had a number of used car dealerships to visit, we made an appointment to basically visit several of them in one day. And we went to this particular one with the representative, and I took some pictures, and we visited with the owner, and we basically told him these certain things are occurring, and they're out. You're going to be out of compliance with your zoning if they continue. And I think he was very grateful to hear this in person, and we were able to answer some of his questions that he had about compliance. And I promised him an email before the end of the day, basically following up on my conversation in person, and that's something that I always do. I'll tell you in person, and then I'm going to follow up in writing. So I'm not going to tell you anything in person that I can't put in writing, and so that's what I did. I basically asked him politely, if he would go ahead and deal with the issues and just let me know. And lo and behold, the next day, I drove by there because I was going to work, and the site was completely cleaned up. He had customer parking delineated. He had cleaned up the cars that were parked in the right-of-way and over on the neighbor's property. He was able to show me that he was only doing repairs and detailing to cars that he had purchased for sale on the site, which was permitted, and that all petroleum waste was collected. So this was one of those successes that Darren was talking about. Generally, you talk to folks, they want to be in compliance. They don't really want to be the troublemakers, and so this was the case with this gentleman. The second case, and I start to use pictures that you can see are clearly not the sites. They're you know, going back in time, at one point in the past, you know, used car dealers or car dealers in general didn't have to have things like special use permits, and they could pretty much do what they needed to drum up business. But you know, in accordance with this particular locality's requirements, they had to have an SUP, which they had received, but they apparently were not in accordance with their SUP, and we had gotten some complaints from Planning Commission and their neighbors. They were parking cars all over the site. There were drive aisles that were blocked. You couldn't really, if you were pulling in and wanted to go look at a car, you really weren't sure where you would park. And 6 months after he'd opened, he was still displaying his grand opening, so that was a little troublesome. And we're still working with this gentleman. He has moved his cars. He's definitely gotten rid of some cars, and he has delineated customer parking. However, he still has the sign up the last time I looked at this particular case about a week ago. But because that motor vehicle dealer board inspector has been CC'd on all of my written information, he basically stepped up and gave him 1 week to come into compliance, or he will have to turn in his license to operate. The third case we have is a little more complicated. This one is a very old site. It was grandfathered since like the 1950s. At one time, there were a number of dealers on this property, but one by one, they've all sort of gone out of business or moved away. And we have 3 left on this site that are kind of in that gray area with the Motor Vehicle Dealer Licensing Board. Their minimum requirements are maybe not always being met about displaying office hours and actually keeping them. The day that we showed up, the office hours were posted as them being open, but no one was there. That they had actually parked some equipment in their designated parking space for a customer, and one of the dealers we actually realized was not where we thought they were. They were in a completely different building, so that was interesting. This locality also has a blight ordinance, and they have some building code violations, and so we are continuing to work this particular problem. It looks like it's actually going to take us a while. We're having a hard time hearing back from the property owner. You know, they're waiting out the clock and those sorts of things. And that gets to my points about when you have those 10%, you just have to drop back 10, be patient, be very methodical, always be checking back, because people are going to come in and want to know how this is progressing. You know, the mayor's going to want to know, so what's going on that property? And of course the neighbors that have complained, so you're going to want to kind of keep apprised of how it's moving forward.
And I'll just jump in here and say that, again, you know, the difficulty is, okay, you can't get hold of the property owner, or the property owner is being intentionally evasive. That's, you know, when you know you've got to dot your I's and cross your T's. You know, there's political pressure to get this done. You know, it's been dragging out, and now staff is here and we want it done yesterday. Well, doing it ASAP is not the proper way to do it. You got to follow the steps. You got to involve the locality's attorney from this point forward. You know, you just know it's going to be a fight at some level that the courts are going to have to assist with. So, you know, being methodical, patient, documentation is key. And you'll see this again in the next section.
Yeah, thank you, Darren. And going forward, we're going to go into the floodplain section now. And before I go, I do want to tell you that there is a lot of similar enforcement steps with floodplain. The big difference with floodplain is that it does devolve directly from the federal level down to the locality. It does not necessarily go through the state enforcement or state enabling type legislation. And that's the reason for that is because of you know, flood insurance. Flood insurance is made available at the local level through an enabling act at the federal level. The wonderful thing about floodplain is it involves water, and there's a lot of other agencies who also deal with water quality, water quantity, and you know what happens when we have too much of it or too little of it. The U.S. Army Corps of Engineers, or USACE, and the U.S. Environmental Protection Agency, the EPA, are two of the main arms that you will possibly end up dealing with in conjunction with a floodplain violation, or you may not. And again, this sort of goes with the 90% and 10%. 90% of these cases are going to go away when people are made aware of them. 10% are, they may end up going, in one case, as you'll see here at the end, all the way up to the U.S. Justice Department. So your steps to floodplain enforcement are, number one, you adopt and enforce an ordinance. The federal legislation sets out standards, not guidelines, for what needs to be in your ordinance. All of the states do have technical staff that are available for questions and for, in some cases, on-site assistance. They all have model ordinances. Ours, of course, is available on DCR's website, and I'll give you that address here in just a moment. Floodplain enforcement is very inspection heavy. You're going to end up doing some inspections, sometimes even prior to issuing the permit, but certainly during the time that work is going on, and always on the back end, you will need to be doing inspections. You have a very high authority to issue stop work orders almost immediately if you feel like that's necessary, and unfortunately sometimes it is. You can revoke permits. There are processes to document exactly what was going on through a hearing process, and in some cases the Section 1316 process, which is a case that I'll discuss here in just a moment. You hopefully will never have to use that, but it's a tool. If you need to, it's available. Here's the address to go and take a look at what's available at DCR's website, Guidance for Local Floodplain Ordinances in Virginia. It's a model ordinance and a model floodplain program guidance document, so that your local ordinance in Virginia should be pretty much in line with what this is. It works both with state law, obviously, as well as the federal requirements. Your inspections, you have the capability to do inspections under your residential building code, which is the section on the right, where it says R109.1.3 floodplain inspections. You have the authority to require documentation that is sealed by an engineer. And on the left, your federal legislation gives you the authority to make as many inspections. As long as someone's pulled a permit, you can make inspections. You can go on their property. You don't have to ask permission. It's always nice to not have to do that if you don't have to. But if you can't get a hold of them, they can't meet you out there, then go and do your inspection and follow up. The little bit.ly thing at the bottom, 2GLUOZB, that is the address for that big long thing. You just write the little one down, it'll take you right to that that federal section of the code if you ever need to refer to that. To know what your authority is. Okay, so violations, as I said before, often occur at the same time other state and federal violations are actually going on. You'll run into these other folks in the field maybe, or you may be the local erosion sediment control inspector, you may be the stormwater person, and so you're going to start to see some dovetailing in floodplain administration with these other things that have to do with hydrology. You always obviously want to notify the person who owns the property, as well as if they have a designated local agent. Let's say they live in Florida, but they're a local real estate agent manages the property. Obviously you could notify them as well. The occupant, if it's a renter, you want to notify them, and you can require that they immediately remedy each of the violations. You don't necessarily have to give them that 30-day waiting period or even a 15-day waiting period. If it looks like the next day that nothing's happened, you can go back and you can actually put a stop work order immediately, as it says here. You can revoke the permit if you have to. Again, I don't want you to think that I'm telling you go out there and start beating people over the head with regulations, but just know in your back pocket, if you can't get a hold of someone, if they seem to be a little recalcitrant, you do have this authority under floodplain administration to do these sorts of things. When a violation is found, oh my goodness, look what's happened. Okay. When a violation is found,
of course, one of our computers just froze up, so we're going to the backup paper system.
Bear with us
which
just a second.
Shows you the experience we've had with technology when you need to do a backup.
Yeah, okay. So when a violation is found, of course, you're going to notify the owner by certified or registered mail. Like I said, we're going to the hearing slide now. You got that one up? Okay, good. You're going to notify them by registered mail that there's going to be a hearing on the property. You have to do a finding of fact before you can go to the next step. Of course, they have a right to appeal the findings, and it may be in your ordinance that they appeal to the governing body. It may be that the appeal is to circuit court. These hearings could, again, depending on your ordinance, the hearing could be held before the local zoning administrator or the building official, or you may designate that they can be heard by the local board of building code appeals or the local board of zoning appeals. And when that decision has been made, you issue an order to alter, vacate, or to remove the problem. They can appeal, like I said, to the governing body or to circuit court, depending on how your ordinance is written. They actually are quite subject to fines and even a charge of misdemeanor if they really want to push it. And so usually at the hearing level, you're going to have a resolution. Usually that's as far as people want to go with this, because it starts to get expensive after that. They've obviously hired an attorney. The attorney is going to tell them they probably need to comply with this. Nobody wants to go, I won't say nobody, very rarely will you have someone that just really doesn't get it and just really keeps pushing it past this point. But sometimes it happens, as we will see. And so when that happens, there's a wonderful section of federal code called section 1316. It says the local administrator shall request that FEMA, through the state coordinating office, initiate a section 1316 of the National Flood Insurance Act action against the structure. And what that does is it makes the structure or the property uninsurable. It goes up on a list that's available to all insurance companies. And guess what? If you can't insure a structure, then you can't have a mortgage on it. So I really can't think of anything higher at this point to me that I would not want to have happen on my property. It does happen. So with all this wonderful verbiage in your back pocket now as your local floodplain administrator, let's go look at some real world examples of what can happen. That's actually pretty common. And what would you think if you've been made aware by a local realtor that there's a property on the market that they showed that was foreclosed and marketed as is, but they looked at the floodplain map and they saw that it was completely in the floodplain, and so they come to you as a local floodplain or zoning administrator, and they say, what does this mean? What is going on with this property? And so, after the housing boom and then the crash, we actually had a number of these sorts of structures that would come on the market where they either weren't finished or they might not have gotten their certificate of occupancy. And so we would be asked to do an inspection and find out, can we get our CO so we can sell the property? So anyway, this particular, and going forward, all of these are actually not actual Virginia examples, and there's a reason for that. The federal law devolving down to the local level is pretty much identical. It can be stronger, but there's a minimum at the federal level, and the enforcement arm is pretty much the same because, again, it doesn't have to necessarily go through the states. So these examples, even though they're in South Carolina, are applicable to similar areas in like coastal Virginia or in other areas of Virginia. And as I said, this particular structure was marketed as is. You'll notice that it has a almost at-grade deck. There's a brick a pad there for an HVAC unit that's not finished. You can see there are some problems here. If you go to the next slide, you go looking in the ground floor, that's sheetrock on the walls. Since the floodplain level was about 6 to 8 inches at ground level at this structure, that was a violation. You can't have sheetrock exposed it's going to get wet during a flood event. The structure wasn't vented. There were no flood vents to allow the free flow of water through the structure so that you would avoid foundation damage. This is the flood map. As you can see, it covered the structure, and as I said, this was something that a local realtor had brought to our attention, and we did a site inspection, and sure enough, found this problem. So I contacted the bank, and believe it or not, he was very, very glad to meet us out there and to understand what was going on. I like to highlight the sections of your ordinance and just give it to him straight. These are the sections we need to work on. and be flexible. You know, they're going to hire a contractor and try to address these things, which this gentleman did. He went in on the ground floor, and the first thing he did was he took a Sawzall and cut all the sheetrock all around. And this was yeah. He did a little bit of damage to some of the what are these things called? I can't remember.
Joists.
Thank you. But he had the studs, exactly. But he had actually elevated the water heaters, which was great. So, you know, we gave him good props for that. The doors, we realized they wanted to have these wonderful French doors that went out on this deck, but being that the deck was not at a level that we could actually approve, it was considered an obstruction. We kind of had to leave that for just a little bit. We'll address that later. So his main focus was to get all of the flood damageable stuff out of that bottom floor, which took all the stuff, all of the sheetrock and things out, and Wonder of Wonders discovered mold up there in the ductwork. Surprise, surprise. Because, you know, generally if you build in the floodplain, you are going to have moisture issues if you don't build to these standards and have it properly vented and properly open. But, you know, the contractor kept working, and he elevated the boxes and took out that HVAC pad, and things started to improve. He did install engineered flood vents and openings in the garage door. You'll see in the lower right picture there's a chalk mark, which is something that we recommend, especially if you're doing retrofits or after the fact, to put a chalk mark all the way around the structure so that the contractors can refer to that line. It's keeping it above the floodplain. Anyway, going back to that good old French door, we called this the goat gate. It had to have openings. It had to be, yeah, it had to have openings. And so this is what the bank decided, because they'd spent some money at this point in trying to get the floodplain problems addressed. And they said, you know, we actually think we found a buyer. We're going to just wait on the back end. If we can get through the compliance process and, you know, in some kind of a way, maybe on the back end, he'll want to do something that's prettier. And so that was fine. We didn't care what it looked like as long as it was compliant. And the building code official was able to, you know, work through some of the issues with the vents and other things. At the end, we were able to issue a compliance statement on this particular property, guaranteeing that it was in accordance with floodplain, and there was therefore, it was occupiable and, of course, insurable, and everybody went away happy. And this is what we ended up. If you'll notice, these French doors are interesting. Look along the bottom edge. You'll see there's a clearance there of about 2 inches. That's their flood vent. You know, because the floodplain, you know, during a 100-year flood event, the floodplain, I mean, the flood water goes up quite a ways up this back part of the structure above the flood vents themselves. It was about 2 feet deep on the back side, about 6 or 8 inches on the front side. So, you know, this is not something that that you're going to encounter every day, but it is an interesting kind of a case. Hydraulically equivalent volume is a method by which you can offer compensation for having put fill in the floodplain. It's an option. A lot of ordinances allow it. There's some engineers don't think it really works, but it is allowable, and under the federal standards, you know, it can be approvable. And so when you put fill in the floodplain, the idea is that you scoop out an equivalent volume somewhere within the floodplain to accommodate the water that would normally have sunk in where the fill is. There was a pond in this particular subdivision that the engineer said, you know, I think we could actually just make the pond a little bit bigger to accommodate that extra flood water that, you know, wouldn't be accommodated on site. So we were able to go through the final subdivision process and approve that expansion of the pond to accommodate the fill. Are we getting any questions over there, Darren?
We are not getting any questions,
okay.
But we also haven't lost any attendees. So
that's awesome.
So please feel free to submit questions if you have any on any part of this.
Exactly. If we're going a little bit too fast, or if it gets a little complicated technical wise. This is an example. It's pretty common of improper venting. You know, I was talking about the flood vents that allow the water to go through. Regular house vents are not going to cut it. If you want to try to use regular house vents, you have to break them in the open position, because a flood vent cannot legally ever be closed. It can't be manually operated or anything like that. So, this is just an example of what very commonly you'll see in the field that you need to help them to address. And again, working with the building official and having him on the same page so he understands what this, is part of holding hands with other people that have to do inspections. This is an example of HVAC and utility connections in a school that was in addition to a church. You'll notice it's really muddy there, and you'll see standing water on the site. It actually had not rained recently. This was a jurisdictional wetland that unfortunately had been built in prior to wetland legislation, prior to floodplain. And so when they went to expand and build this school, they were faced with a lot of drainage issues. They were semi-grandfathered because they were already there, but you'll notice the water table on the building and how high the electrical is on the building. You'll see the fill there, and then I hope you can see that the box that was put in by the utility company out in in the yard is below BFE, and so we had to work with the utility company so they come out and put it in the right place. And as I say down here, Mother Nature really doesn't care where the water goes. She can't read the maps, and that's our job, is to help the property owner understand that these regulations are there to kind of help them make the site work. Some people don't understand that fences and walls, while they may not require a zoning permit or maybe not even a building permit, if they're in a floodplain, they do require a floodplain permit, and they do have to be vented. Otherwise, in a flood event, they will collapse. And this is one way to accommodate venting. If it's in the direction of the water, so the water would continue to flow through, you can use a gate. A lot of times people will just use large openings at the bottom of the walls. Here's an interesting example where somebody, it may be very common, they figure, I own the property, it's my property, so I don't need a permit if I'm going to just cut down some trees and start to build something. And so we had to work with this poor gentleman. And his neighbors, as you can see the houses there in the background, saw him out with his bulldozer and knocking down trees. They called and complained, and sure enough, we pulled up the flood map, and this is what it looked like. He was he was in a very flood-prone area, and as it turned out, he was also in jurisdictional wetlands, and he ended up having to hire an engineer to help him out with some of these problems that unfortunately he'd encountered. This last one is a little bit extensive, and if I've hurried to get to it, it's just because I want to make sure that we get everything here. This is literally probably the worst case scenario, where you have someone who is building a house. He's a contractor. He does not have a mortgage. He's paying everything himself, using cash. And so he's not going to encounter what a lot of times people will encounter on the back end is the bank's going to want all your permits in order. They're going to want your CO. They're going to want to make sure that you are insurable. But he didn't have that problem because he was paying cash. It is very common for the U.S. Army Corps of Engineers to get involved when you place fill in a floodplain, because a lot of times you're covering up jurisdictional wetlands. And they will require things like full-page ads to let the public know that you did something bad and you are now having to fix it. They might require that you buy a billboard to advertise how to go about getting permits, interesting things like that. So this gentleman, during a routine building inspection, he pulled his permit, but he placed a lot of fill on the site, and when they went to do inspections, they found this fill, and so they pulled me in. And his idea was that he had bought this wooded piece of property, but he wanted to have a nice yard, and he wanted to have a nice flat area for a pool, for a deck, and things like you would normally expect to have. But being that the property was in a map floodplain and jurisdictional wetlands, this became very problematic for him. Here's another picture of the site. You'll notice that there is a sewer easement through the site. I don't know if you can see the public utilities features in there. If you want to see right there and over here on the side too. That's a public utilities easement for a sewer line that went through the property, and he put fill on top of that. So public utilities got involved. He had to go and kind of move some things around. And I always said this: there's some properties is a reason that
nice private property, no trespassing.
But even so, he had posted the property. We still needed to come to our inspections, and as I had referred to before, they cannot prevent you from coming to do your inspections. But this property was actually a 22-acre parcel down at the end of a subdivision that had never sold. And we always said, there's probably a reason why it never sold. It was always going to be hard to develop. It had some slope. As I said, it had a lot of jurisdictional wetlands and floodplain in it, and it just devolved into this thing. This is what the property looked like before he developed it. You see the swollen bases of the trees and the cinnamon ferns and things like that that are going to normally tell you you've got some wetland issues. This is my car parked on top of the dam that was directly in front of his house. So you didn't know that, did you, when you looked at it from the street? That the house is actually built right behind a dam. That gets interesting at this point. When you've got a lake and a dam, you're gonna always encounter some Clean Water Act regulations. So you want to be very, very careful when you start to develop so that you don't trip up and trigger things. And unfortunately, because he'd already started, he did trigger some things. And so the U.S. Army Corps of Engineers brought the EPA in pretty early on this. And here's another picture of the site before he had removed the fill. And if you'll see things like, he had put about 36 inches of fill in this front yard area. The trees were all... you don't want to put fill around the base of trees, especially in a wetland, because the trees are going to die. They have to breathe. Unfortunately, we did try to work with this property owner probably a little longer than we should have verbally, and just trying to explain to him, these things need to be, you need to get permits, you need to file some plans, for your fill. Eventually, we told him you're going to have to remove that fill because it just didn't appear to be any way to permit it. It was literally 2 acres of fill, about 36 to 48 inches deep. And so we ended up having to cite him, and we met with him and the other officials involved several times. Unfortunately, he started having problems about 8-9 months into the process because he built in these very challenging areas. The foundation was settling, and it caused him a lot of headaches. Here's some area where the fill was placed, and on the dam, I don't know if you can see up top, but right across here, that's the top of the dam. And this was about 300 feet into the interior of the site, where he had attached a pipe to the outlet of the dam, covered it with fill, and tried to pipe the water that was coming out of the outlet at the bottom of the dam to an area behind his property that he thought was a little more appropriate. So, we told him that the pipe and the fill was going to have to be removed, and we first thought it would take him about a 2-year process to stabilize the property if he would please follow the directions. And the Army Corps and EPA and Dam Safety actually got involved there, and the state. Pretty much we were all, like 5 different people were having to go to this site about once every other week to see what was going on, and were things happening. Unfortunately, he just kept doing things. He, like I said, was a contractor. He brought in about 30 dump truck loads of fill over a couple of weekends. And at this point, what do you think the neighbors were doing? We were getting calls, 3 and 4 calls a day at one time from this gentleman about, what is he doing? What are you all doing? Why are you not making him clean up this mess? So it got very, very difficult. And over a 3.5-year period, I worked with this gentleman to try to get him to get his site into compliance. Like I said, working with multiple other agencies. At one point during a rain event, a lot of stormwater that was full of runoff from his site went out into Second Mill Pond and caused a fish kill that the U.S. Fish and Wildlife Service came upstream looking to see where all that dirt had come from, and so they got involved. The equipment on the site are normal size pieces of equipment. This pile of dirt from the top to the bottom was about 22 feet high. So you can see that this is rather a substantial enterprise. And when we made him remove the pipe, you can see there at the lower left what the dam outlet pipe looked like after he had removed the fill and the attachment that he put onto it. But instead of allowing the dam to drain normally, he dug kind of a lazy river through the site. And at this point, the U.S. Army Corps of Engineers and the EPA basically just escalated it up to the U.S. Department of Justice. The poor gentleman was actually jailed for 12 days at this point. And this was way out of my hands at this point. I just was sort of an innocent bystander, just watching all this stuff go by my desk. But eventually he did hire an engineer, and he started to work with someone, and the site basically sat for several months while the engineer constructed some plans, including a replanting plan for the trees that had died, and the neighbors kept calling. But eventually, I was required as the local floodplain administrator to be the first person to okay what was submitted in line with our ordinances before the EPA or the Department of Justice would actually would release him. His engineer filed a plan that met my ordinance. They had planted about 150 trees. They put a 3-year stabilization plan in place that covered the 19 acres behind his house, put it in permanent conservation easements so that it couldn't be developed. And we were required to sign off on all these plans in order to get him through the compliance process with the U.S. Department of Justice. So that was really interesting. But it actually looked like things were gonna be okay. And then I left Sumter and came to Virginia, and I went back a couple of years ago to see what Google Maps showed me. And I understand that the poor gentleman actually passed on, and his son now owns the property. It looks like it's still probably recovering. The area behind his house and then back up to the north, or on, I guess it's, if you want to show them here, all this area is under conservation, just because of the little 2-acre area that he had done work in. But the house looks like it was finished. It looks like it's nice. But at this point, this gentleman has paid hundreds and hundreds and hundreds of thousands of dollars in compliance and enforcement and fees to his engineer to try to get him out of this mess, and fines. And so I guess it was a real learning experience for me as an enforcement official, just to see something go all the way that high.
It just, to me, it illustrates when we say a simple 3-step process, we're very aware of the complexities that go into this, and it's not always that easy. But as you said, y'all probably messed around with this guy a little bit too much at the beginning, and that's why 1, 2, 3.
Exactly.
It's you fix it, or lower the boom and go to court.
I should probably mention that when the EPA got involved, the first thing they did was actually cite Sumter County, because they assumed that we had not done our job in the permitting process. And fortunately we had, and we were able to prove to them quite quickly through a few emails and faxes and stuff of, this is what we told him, this is what he said he would do, and this is what he didn't do. So thank goodness. But they came into it, they were going to cite us just as badly as they were going to cite him. And that's something I think you need to be aware of as a local administrator, is that you are answerable to the public for how you run your program. Hopefully that will never happen to you.
That's an excellent point. It's one thing to have the property owner going to court and getting fined, but you definitely don't want to place your jurisdiction in that situation due to negligence, gross negligence. All right, so that is it. The slide that's up is who we are and how you can contact us. We still don't have any questions. And we've got 5 minutes if anybody would like to submit questions. Otherwise, we really appreciate the attentiveness of the audience, and we are very happy to be sponsors of this lunch webinar, and look forward to what 2017 has in store for us in terms of topics. Martina, I think
I'm here.
Do we have any?
Oh,
All right.
you do have
Tell
a
us
question.
again when this recording will be online.
Yes.
That's for you.
They'll be posted within the next 24 hours, and we'll send an email out to everybody who registered for this with a link of how to get there.
Okay, excellent. Thank you for the question. We got one. Does anyone else have any subject-based questions or otherwise? I will say, just as a side note, that the fact that these are being posted on YouTube, I think is just awesome. So, Martina, thank you, and Eldon,
no
for the
problem.
job you're doing with this. It's this technology is frustrating / amazing, and it's really cool. I like being able to go to YouTube and see how many people have clicked on these things.
Cool.
All right. Well, we will wrap up then, and thank you guys for leading this. And like I said, everyone will get an email shortly about where they can find the posted webinar. Have a great afternoon.
Thank you.
Thank
You too.
you. Thank you. We appreciate it.